Good evening. Today is September the 14th, 2022, and the Board of Appeals is now in session. All right, so good evening, everyone, and the meeting is now called to order. Let's go ahead and may I have a motion for the approval of the minutes?
I make a motion to approve the minutes from the Board of Appeals meeting August 10th, 2022.
May I have a second? Is there any discussion on the minutes? It's just last month. Okay. All right, if you're hearing no further discussion, I'll call for the vote. All those in favor say aye.
Aye. Aye.
Opposed? Okay, the ayes have it, 5-0, and the minutes are now passed. All right, tonight's agenda, we're going to actually, we don't have any cases before us, right, Caroline?
That's correct.
And perhaps I'll turn it over to Caroline so you can give us an overview of what our work session will be like tonight.
Sure. Thank you all for being here. It's good to have, I'm glad we got to do this with everybody. It's a rare occurrence. This is a work session, essentially the same one we did maybe 4 or 5 years ago. I think some of you were already, a lot of you were here for that, but we do have two new members, and it's always good to have a refresher on everything Board of Appeals. So this is really the same presentation we did the last time we did this. Frank is going to take the lead on it, and then we'll end up with any questions you guys have, and that's our whole agenda for tonight. So I will turn it over to Frank. We've set up everybody's computers so that you can just follow along, and I printed out the presentation in case anybody wants any notes. You should have all of the slides in front of you.
Thank you.
Take it home, do whatever you want with it, and that's it. I'll turn it over to Frank, who is making his reappearance here at the Board of Appeals. So welcome back.
Yes, I'll introduce myself. I was, I think 4 of you will remember that I just like to say a few years, because if you get into detail, it comes close to 10. But I'd served as the board's counsel and had continued. I think we changed that in January or February this year, and Eric's been here, and Eric's been doing a good job, but we kind of made a decision to unify the planning boards. That means Eric will remain a backup, so you may see him again, and he'll still be involved if we're having conversations or discussions, so he's aware of what's going on. But in any event, I won't make the bad penny reference, but somewhat like a bad penny, I guess. I'm back and certainly pleased to be here and pleased to be working with you as we have. And when I heard about this, one thing I will point out, we actually could do a full open meetings training either for the board, and this would be the certified training that is statewide, that if members needed to be certified. I don't think there's a special need for you, but it would be possible for us to do that if there was a desire, even citywide, because anybody attending, we would be able to have certification, which is required by state law. So just an FYI on that. But I do know 4 of you. Mr. Cook, I don't think we have worked together, so I will say hello, and I'm sure we'll interact. And I can't see your name tag, sir.
David Belger.
Oh, yes, indeed. Okay, I somewhat recognized you from a couple of months ago or from last year's election proceedings. So glad to see you and look forward to working with you as well. And Caroline, I guess if I can say next slide, please, we can move through that. And I think that Caroline and Greg and Jasmine is also aware of some of the details, so I can certainly take the lead, but if they want to pitch in on there are some specific points that they want to make regarding the provisions that you deal with under the city code, but I'd also say if you have questions, it's better to go ahead and ask as we get as we get through. That way, it's a fairly short presentation, but that way we'll know we've certainly hit on the main topics. In terms of where we're headed, this is laying out some of the basic processes. We'll touch on some applicable law. We'll talk about the processes, and then in terms of who's who, and this is mainly review, because I think by now you should know, but Caroline is what I see as lead liaison, but Jasmine as well. And of course, Greg Mann is here, and he is also involved. Eric is Assistant City Attorney. As I say, you may see him again, and then I'm also in the City Attorney's office, and I'll be the primary one that will be here. You know your officers, Carol and Aaron, and I have enjoyed working with you, and glad to see you again too. So what are you here to do? If there's any question there, you really have three main things: variances, special exceptions, and administrative appeals. And we've got a couple of slides that will detail a bit of what that is. For some, it'll be a review, but always helpful to touch in here. So, so what do the different elements do? Well, your liaisons maintain the record, help to arrange meetings. We'll certainly review what has been submitted, which I think you would certainly agree is extremely helpful. Draft staff reports and recommendations, as well as resolutions, then for your review. What do? I assist with legal questions and guidance where I can, like tonight, a measure of training. What does that involve? Process, interpreting state and local law, as well as certainly the rules of procedure. And you do have a rules of procedure, which also, it's not something you have to touch on all the time. You have been able to operate, I think, partly with the experience of your members and the experience of your chair and vice chair, without the need to, let's see what Rule 6 says, or let's see what Rule 5. You're essentially trying to rule on the three. Mainly what you deal with are the special exceptions and variances. There are appeals that do happen from time to time. And simply make the right decision according to the city code, and sometimes I use your example in talking to other commissions as to a good way to proceed. So there are annual elections. That's pretty much all of the rules for all the commissions have that, and that's generally the first meeting of the year, and sometimes it's postponed if not everybody's present. So next slide, please. So we were talking about the board role, variances, special exceptions, and appeals. So what's a variance? Well, there's actually a definition in the zoning code, chapter 24:1, if anybody's ever interested where we get it from. And a variance is essentially a modification of several provisions that the zoning code or the will identify. And because of something that's peculiar to a particular property, literally enforcing the law with unblinking, just to say, well, you have to have a 10-foot setback, or you have to have a 30-foot setback from the front, would create an unnecessary hardship or practical difficulty. Now, that's a broad standard. Typically for variances, you'll want to go through and make sure that certain standards are met, but the basic rule is if it's an unnecessary hardship or practical difficulty, that's really the element. Next slide, please. And that's the power also of having staff review and provide you with the details and the background as well as applicable city law. It's still your decision. You still may have questions. You may have, for instance, changes or additional conditions that you want to add, but in a specific case that will lay out, well, this is why this is a practical difficulty, and that's intended to be a broad standard, because unnecessary hardship or practical difficulty can be a fairly broad standard to apply. In terms of special exceptions, well, those are exceptions. That's granting a specific use that wouldn't be appropriate generally, just overall within a zone, for instance, without your review to add some measure of restrictions. Now, it has to be authorized by the city code. Many times there are additional standards that have to be in place. It has to follow the master plan. And then it also has to fit the community. It's got to be in harmony with the community character and can't harm the community. That's putting you in a position to protect that community from an exception that isn't intended to be generally available and used just because somebody wants to do it. So in some ways it's a lot of authority. Many times these are granted through conditions, and that's the power of these conditions and the importance of these conditions to make sure this use isn't going to go past a certain hour at night. This isn't going to be on the weekends. You're only going to have this many children involved. If, for example, it's a child care license. And the next slide, please. And the third one is administrative appeals, and that's person has a right to appeal. Now, this isn't outside of your peer review. This would be generally some sort of a zoning or a planning decision. It's any final order, requirement, decision, or determination by staff. That can mean a permit. If somebody doesn't like a permit, that's what you do. That's one of the things you're here to do. So if you think about it, that's an important due process element. It also can be from Planning or Historic District Commission. And if that happens, you probably will see Eric here, because I would have a bit of a conflict in representing one commission while also representing you in its review. What do those appeals have to do? It's not just that somebody's unhappy or they don't like something. It has to be, first of all, it's based on the record. So you don't make a new decision. It's based on what happened before. And for that appeal to be successful, in other words, for you to be able to rule in favor and say, well, there's got to be a change, there has to be an error. There has to be either a factual mistake, a legal error. There has to be something wrong with it. And that's actually the administrative appeal part. While you don't see that many, it's one of your more important roles, and that's actually laid out fairly specifically in the article of the zoning code that's devoted to the board. I believe it's Article 7. So next slide, please. So in making all of these decisions, you aren't judges, but you are quasi-judicial, and that is a critical role for the city, but it also imposes certain burdens on you. First of all, obviously it has to be decided on the record, and it has to be based on applicable law. So that means in terms of process, there has to be prior notice, an opportunity to be heard. This is always held at a public meeting. People have the right to speak. You're all familiar with that. It also requires impartiality. That means no bias, no prejudice, no conflicts, and something called no ex parte communication. And we actually have a slide where we'll explain that a little bit. It is related to the fact that it all has to be based on the record. There are appeals allowed from your decisions. That's to the circuit court, and that could be from your decisions for anything, whether it be special exception, variance, or certainly administrative appeal as well. Basically folks have 30 days and then they can go to the circuit court. So next slide, please. So that ex parte rule, what are we talking about? And actually there was a Court of Appeals case from I keep saying a couple of years ago, and come to find out, well, no, Frank, that was 4 or 5 years ago. I was one time commenting to my wife, and it wasn't that long ago, saying, yes, 495 has always been a mess. I remember when I was going to college at the University of Maryland, it was the same way, and that was only, that was like 10 years ago or so. And she said, really? When did you graduate? Well, okay. It was a few more than a couple of decades ago, but anyway. So what does ex parte mean? As I said, it's on the record. That means every decision you made, there's got to be evidence on the record. And bear in mind the importance of that is if there is an appeal, the circuit court, which is the body that would take an appeal from your decision, will be looking to the record to see does that record show substantial evidence to justify that decision. So it's all on the record. any discussion, correspondence, information you receive that's outside the record, other than basic judgment, such as if it rains, it's wet, or in private, to which the other side's not aware. That's all ex parte communication. And if that's engaged in, such as, let's say you have a community group that's very upset about an application. You've had that. It happens once in a while. Your role, again, think of yourselves, quasi-judicial means you're quasi-judges. That means I base it on the record. My role is here. If somebody in the community says, well, I want to have a conversation with you, like, actually, you need to have a conversation with the whole board. We will have a public hearing. You will have the chance to speak. If somebody wants to send you an individual letter or something like that, that should be shared with everybody as well. Ex parte communications are prohibited simply because, by definition, they're not part of the record. They're also, it's not something that the other side is aware of. That also adds additional problems. If there's an ex parte communication, that's going to raise a serious question of substantial evidence if there is an appeal.
Question about ex parte.
Yes, sir.
Excuse me. It's not considered ex parte if it's communication that happens prior to the matter being officially on our docket, correct?
Well, there would be, if nothing has happened yet, that's correct. At the time there is an application, then the ex parte rule would apply.
Mm-hmm.
Now, for other reasons, depending on what that information is, if it's just something basic that, yeah, I know where that property is located, that shouldn't be an issue. But if you do have enough engagement or enough information that, again, that's not part of the record, but if in your judgment, or in looking at our ethics rules, which is Chapter 7A, if there is an actual concern there with your ability to be fully impartial, and sometimes that's a subjective decision that you have to make for yourself, then you would want to recuse. But in most cases, if somebody, for instance, wanted to say something to you who may have a future application at some point, if there's not a live application, it's not going to violate the ex parte rule because nothing's happening. Once they file the application, though, it would.
Mm-hmm.
And again, that's where I'd say if that prior communication, oh yes, I talked to you 2 or 3 years ago about this, and then it turns out, oh, now you're filing a special application, you have to judge for yourself, well, is that a problem? Typically, what we've had members do is say, yes, I've talked to the neighbor, or I've seen this across the street, or he mentioned something to me 2 or 3 years ago, but I don't think it's a problem. The easiest way to deal with it is disclose. Everybody hears it. If somebody has an objection, they can object, they can ask. In most cases, the disclosure is sufficient, and then it's your judgment. Typically, my guess would be, you would probably say, well, I don't see that it's a conflict, so I'm prepared to stay unless somebody else has a concern. If there is no concern, and here's what happens. That has been raised as part of the record, and for somebody then to later say there's an issue, it's not going to be taken that seriously, and the court's going to essentially reject it if it was raised on appeal, for example, because it was raised, it was discussed, you were there, and you had the opportunity, and you said nothing about it. So, if there's ever any question about that, that's one reason I'm here, and certainly Caroline, Jasmine, Greg have also dealt with the same issue, and we're all here to help you make the best decisions you can. Next slide, Pete,
Took the
please.
words right out of my mouth there. I was going to be right behind you. You said it already.
I'd already touched on this to some extent, but when an ex parte communication is proposed, it looks like it's going to happen. Again, best rule, hey, we're going to have a public hearing, come on out. And sometimes it can be difficult to say. We're a municipality. I believe for this board, all of you have to live within the municipality.
Mm-hmm.
For certain ones, such as HCC, you don't. And for a few other of the city commissions as well. But what does that mean? Well, we're not the size of Montgomery County. It's going to mean that you're going to know some people. We've had a few say, that might be across the street. Well, that's going to happen. But if somebody does come up to you, just say, look, these are the rules I'm stuck with. Come to the public hearing. We really can't do this because the other side has to be aware of it, and everything I decide has to be on the record. Folks can submit a letter. They can participate in the hearing. I believe they even have, do you allow it by Zoom?
No, we do not. We're
We do
all
not.
on,
Okay.
Right.
You see, it was smart of me to ask because some commissions do and some don't. And typically, if you have a concern here, your decisions tend to be based on a specific property, which may mean you'll have, if somebody's concerned, you may have a handful of neighbors concerned. Folks can also submit a letter, and of course nowadays a lot of that's done by email as well. So, next slide, please. The rules of procedure, which I had mentioned, actually the next couple of slides kind of run through what's there. There are 11 chapters, pretty basic. You actually had rules of procedure that go back a decade or more, and so the current ones are based on that with a few updates, I think, that we've made over the years. But it lays out how appeals and petitions are filed, notice requirements, hearings. Next slide, please. You're reaching decisions, rehearings. We have had that, as some of you will remember, I believe, last year. We did have a request for reconsideration, and lays out who the officers are, communications, and again, underscoring the no ex parte rule, which you all just heard. And next slide, please. So we've been talking about the record. The record is not only what you consider in an appeal to you from a staff decision or planning and zoning and historic district, but also if there's a record, if you're appealed, it's going to be based on the record as well. What's the record? Pretty much everything. Documents, transcripts. It's going to be the public hearing, if there's video, photos, diagrams, as well as a record of your discussion as well. That's all part of the record. Again, I've mentioned the circuit court standard, substantial evidence in the record. Now, the person who is appealing, who is asserting they made a mistake, they have the burden. Often, though, in an appeal, many times we've had appeals from the Planning Commission decisions. We've had appeals from the City Council's decisions as well after a recommendation by the Planning Commission, and have demonstrated that we followed the rules and followed the process. Often if there is a gap, a circuit court will remand and simply say, well, I don't see substantial, not just do a reversal, but say, I don't see substantial evidence to support that. I'm going to remand it back and make them go through the hearing again. While the burden's on the person appealing, the circuit courts do look at the record, and burden or not, they are looking to see, is there substantial evidence to satisfy the court? So that's always an important element. Next slide, please. So what should that record have? And this is one thing that I recall, and I believe you would have continued it because you have the same chair, that you do very well in terms of showing your reasons for the decision. One of the things, I believe it was the Historic District Commission that I first noticed doing it a couple of years ago, was if there was, because it's very tempting to say, oh, this looks good, motion second, pass, done. Minimum of discussion. And what I saw the chair there frequently do was to say, well, let's actually create a bit of a record and say, what comment do you have? What do you think about that? And many times there may not be a tremendous amount of questions, but each member is going to say, well, I think it does satisfy the law and this is why, or at least something. that's a powerful creation of a record, because the elements of the record there is not so much the documentation and the evidence, but that it was actually seriously considered and there was a basis for that decision that was eventually made, and each member was part of it. The ones that are remanded are frequently, well, I can't see what the basis of it was. They were apparently looking at a staff recommendation, but there was no real discussion. It doesn't mean that a decision has to go on, and there has to be an extensive discussion, but the value of having that input from all of you, as again, that is the creation of a record, and that also does make sure everybody is engaged. It also demonstrates that for the record as well, and actually that can help staff in making the recommendations to say, okay, I'm hitting the mark, because again, we're here to serve you. So again, that's why that last paragraph's there, because that is an important element. The best record, may not always, but it is important where we can to have comments. Sometimes the comment can be, I agree. Well, that's what the record is showing, that it was considered, and clearly all of the members are in agreement.
So
Next,
Frank,
yes, ma'am.
so just to reiterate that point about participation by the whole board, that oftentimes I think many of our questions are found within the documents we receive ahead of time, and that each one of us bring a different background by our professions.
Right, that's
Sitting
why
at
you're
the
here.
table, sitting at the table here, or at the table. So I just wanted to say, I guess my question would be, in developing those questions, the questions can also, it can be based on what's there, but then it can also be based on just curiosity from the board member themselves too.
Sure, and it's not always now, I'm not necessarily saying, you may or may not have questions. When you say questions, I assume questions of the applicant or the petitioner.
Or even the nature of the case, the administrative cases are different than the special exceptions, and the special exceptions are different than
Mhm.
the rank and file cases we get, so.
Yeah, no, if you do, regardless of whether it's a question for staff or a question for the applicant, that's fine. The point I was making is that there's a basis for the decision. What is your conclusion? Do you
Yeah.
have further questions, which is fine. That can be one. Frequently that happens too. Well, I'm not really sure. I have a question on A or B. What was happening here? Why did that happen? That's an important element. But it can also be, well, this is what I conclude. I think it fits, and this is why. I think it shows substantial hardship. This is certainly a unique property, given the way it's, sometimes for the setback reductions from, say, 10 to 8 feet. We're not granting somebody a special privilege here. This certainly looks to be a hardship or a practical difficulty. That's important just to show that the members did that. It can be valuable. For instance, if you would typically have 5 plus yourself, just to say, okay, Board Member Cook, what do you have any reaction? Giving them a chance. Board Member Chiswell, what is your opinion? Do you have anything to add? And just giving the brief. That's all that is. And sometimes it may be questions. That is the value of your different backgrounds as well. That's why you're here.
Okay, great, thanks.
I just wanted to add to that, in the process of creating a record, some of the items, and they're always going to be in a draft resolution if there is one. Section 24-189 are the findings that are required for the Board of Appeals, and it can serve as a guide. What do you need to agree with, conclude? Especially for special exceptions, there are 8 things in there that are kind of laid out as things that you can use as a basis for either approving or denying something based on what's in 24-189. So that's useful for you to have out when you're having a discussion to say, I think this is in in conformance with the master plan or any other thing that's in there.
Okay, yeah.
Right, that the special exception won't harm the community,
Right.
but the key part is, these are the standards you apply. Well, that's what the court, if it's ever looking at appeal, would be looking at some evidence that, okay, that was considered, and in fact, the board did decide, it's very clear the members did agree, these standards were met. So, next slide, please. So for open meetings, board meetings are generally going to be open, unless there's a special reason to close them. Prior to the meeting, part of the Open Meetings Act, that there has to be reasonable notice to the public, that alerts them to the meeting. An agenda is sent out at least 24 hours ahead of time, and typically with more time than 24, that's simply a minimum. And the point of that is that the public has a general right to observe the deliberation of public bodies. So in terms of discussions, considerations, questions, dialogue back and forth, that's the part that the public has the right to observe. If there is a need, legal advice is one of 15 exceptions that do allow meetings to be closed. Probably in most cases, yours would be receiving legal advice, and it is getting legal advice from counsel. Often, though, just because you have a legal question, and I have often said, actually, there's typically not a bad reason for everybody to hear this, because you may have a good question, and that way there's an understanding of both sides, and anybody else who's watching, oh, that's the law that applies. Because sometimes it's important for you, sometimes it's important for others also to see that that's going to be the law that we apply. There have been instances where there is a specific question, and that there may be a need to close for advice. Next slide, please, because that lays out. In terms of process, it's better that we do know in advance, because if a meeting is to be closed, there is a requirement to put it on the agenda. That's not to say if there's an emergency need that something should come up, something that was unanticipated, that a closure process can't be gone through. There are some practicalities. For instance, if the meeting's closed, that means it's only you, and then any staff that would also be part of that. So that can mean if you have an audience, what do we do with that? I believe in the past, we've had a couple of instances where we'll just go upstairs. Now everybody can hear us walking around upstairs, but they generally can't hear what's being discussed. But what I would say in terms of a closed meeting, just because you can doesn't always mean you really need to, or that it's useful. But then again, the process is there.
Could you give an example of a legal question or issue that might rise to the standard of needing a closed meeting?
Sometimes that will be subjective on board members' part, but if there's a fairly complicated question that applies, and we are looking at what several opponents or supporters may have been saying, to the point that even getting into the question and the details, it's going to be hard to keep the crowd from getting engaged and wanting to interrupt, that in an instance, that's just one example, that's not to say that's the only one, but that might be one where say, you know what, let's work through this one so that when we are ready to then proceed, we've worked out, this one said this one said this one said this, and how does this all add up? So I think it would be rare, but certainly not impossible. I think even there was a time before, I think, as it turned out, probably a few months before I actually started, as I had said earlier, back a few years ago, that there had been hearings that went on past midnight or even later. I think dealing with some cell towers.
Yeah,
or
that
cell-
case-
That was one.
That
Yeah.
case went on for 18 months,
Ah,
one case.
but it was not 18 months continuously.
No.
They did have breaks and all that, so it wasn't.
Yeah, but it was
Yeah,
18
That'd be
months of our
very-
lives,
Yeah, that.
thinking about it.
And it can happen. I mean,
It
if
can happen,
anything, I
right.
would say we're in a little bit more of a time when folks are, the public is watching what is happening and concerned about their community, and so
Yeah,
that can always happen. Certainly learning experiences. In terms of the closing process, when there is a need to close, we do advance notice is better, and sometimes it can be advance notice saying, well, it looks like it may be possible, and that way, if it doesn't have to happen, it's not an issue. It does need to meet an exception, but there also has to be a reason for it, as opposed to simply saying, well, we're getting legal advice. It may be simply a matter of legal advice on the details of the special exception law as it applies to this application. There does need to be a motion. There does need to be a public vote to close. Everybody needs to vote yea or nay. And then at the next meeting, typically, then the minutes will identify what happened, who was present. There's actually a list of up to 7 things that are included. And the chair, actually, there is a form the chair should fill out. It's not technically required because we have a number of folks who are certified, trained, and are present, but we still prefer using that form because it's the safest way to do it. It's basically the Attorney General's form that identifies this is the reason to close, this is the exception that applies, this is the vote to close, and that way that's also then part of the minutes.
so then, Frank, we can close the meeting during the meeting, and then we can also reopen the meeting during the meeting too. Once it's closed doesn't mean it can't reopen in the same
Yeah,
evening.
it could. Typically, if there's a need for a closure, and if it's known in advance, it's at the beginning or the end.
Okay.
And part of that is, now, what happens in that case, let's say there was a need for a closed meeting, and sometimes that can be training on particular topics. Although typically there's not a need to close for that, let's say there is, that would be, well, we're going to start a half hour early. Well, you put out notice that you can start out early. You start out down here, motion to close, and this is the reason why, meets the exception. Then there's closure. Go up, I think we've done it, maybe not with this board, but it's been a few. Do a training and then come back down and start at the normal time. And that can be reopening. Sometimes it's at the end as well. They say, well, we're at the end and we now are going to have a closed session, and then we walk through the process. And very important to always have a public vote to decide that issue.
Okay, thank you.
So, next slide, please. And both the public information and open meetings are part, if anybody's curious, part of what's known as the General Provisions Code of Maryland law. So, general provisions doesn't sound exciting, but it certainly keeps us busy sometimes. In terms of public information, sometimes it's known as FOIA. Well, that's a federal request, or a Freedom of Information request that's more at the federal level. Maryland's is known as the PIA, the Public Information Act. It does rely on federal law if there's a question, but generally speaking, public information is going to be anything that you deal with. You're probably not going to have your records with that much of a request because they're already public information. If somebody wants to see the record,
Yeah.
they can certainly file a request and that can be provided, but it certainly includes minutes, documents, evidence. However, that third little bar there also includes communications between members and with staff. One thing they had just come out with email not that long before, because I served on a board in a smaller town where I was living at the time. I think it was Board of Appeals, Planning, and also an elected office there for a while. And, communication was kind of neat, and I'm going back 20, 22, 23 years ago. And you would see these detailed discussions, and you would think, are you thinking this is going to disappear? Because you should think of emails as is it something you would be comfortable with having on the front page of the Washington Post or carved in stone somewhere? Because once it's in an email, once somebody else gets it, it's all but permanent. Because you don't know who else has seen it then. I mean, I think there was a movie on a question of making sure a certain video recording of something was not revealed. And so they were very anxious to get that copy. And when they got that copy, I think it was called Enemy of the State, as a matter of fact. Well, then, I think the question came up, well, but I did send it by email to somebody else. Well, at that point, there might be 10,000 copies of it out. It might be on Facebook, and it may well end up on the front page of the Washington Post. That's just an underlying a matter of caution. Be aware that your email communications, regardless of whether it's your personal email, which it typically would be, whether it's between members, certainly between staff, we may be able to, if there was a question for me on legal advice, there is some measure of confidentiality there. Certainly if there was a personnel issue or personnel records, there are laws under the PIA, the Public Information Act, that do create fairly large areas of confidentiality. But for most of what you are talking about or discussing, they're public matters. So just be aware. I've never heard that there's been a concern or an issue, and I actually think all of our boards and commission members are fairly careful about that and just come here to do the job. But just be aware that sometimes a person who doesn't get the application they want will put in a request like that, so it's not impossible that you all could at some point see a request. Well, do you have any emails where you were discussing anything? And if the answer is no, well, the PIA can only disclose what we have. It's not a matter of analyzing or putting together information. And if the answer is no, I don't have anything, that's the end of the question. Next slide, please.
I have two associated questions.
Okay.
The first, they kind of circle around this and ex parte. So the first is, would a discussion between two members of the commission, I want to say committee,
Board.
of the commission.
Board.
Board, thank you. There we go. I knew there was a right word.
It's the first word in our board.
That's right.
Easy to remember.
Brain. But if there's a discussion between two members of the board of a matter that has been appealed but we're not yet at a meeting, is that considered ex parte? That's one. And associated with that, my understanding is if a certain number of the board committees are together at some point discussing something, that could be considered a meeting?
Yeah, I'll go back and talk about that issue of quorum as a separate question. You are able to talk amongst yourselves. However, if you're having a dialogue among more than a quorum, and since you have 5 members, a quorum is going to be 3. So one-on-one or one-on-one might be fine if you have a question or something like that. You're allowed to do that. If it's not involving another party, it's not involving the public, but it shouldn't be presenting evidence between the two of you because the two of you are making a decision.
Mm-hmm.
It shouldn't even matter whether there's an application or not because you're all part of the same board and you're all trying to make a decision. I, for a time, was, actually for about 10 years, was serving Carroll County commissioners. At the time, Carroll County commissioners had 3 commissioners. And I was not especially well versed in local government or Open Meetings Act. And so I thought, well, this is going to be great because I know all of them and they're all really great folks. And we're just going to be able to sit down and talk about agendas and what we're going to be, what they are going to be doing at the county commission meetings. And in fact, because any 2 of them was a quorum, none of those discussions could happen under the Open Meetings Act unless they were talking about personal affairs or whose next birthday is coming up. So I'm very well aware of that. You're a 5-member board, so if you have a question, now it can be personal, but that's not going to be a problem. But if it's on an application, one asking another, that can happen. Certainly you can ask staff. The thing I would not recommend are reply all emails. I'd say we went for 8 or 9 years where the Open Meetings Compliance Board was saying, okay, we've never found an email exchange to constitute a violation of the Open Meetings Act, but we're warning you. At some point we will. Well, I always advised everybody when the issue came up, they're saying at some point they will, let's not be the one. Well, a couple of years ago, Talbot County was the one. I mean, they certainly didn't. I mean, the issue they were dealing with was actually trying to put together a letter of support for legislation before the General Assembly. Typically, anything before the General Assembly, you've got about 30 or 45 minutes to make a decision as to what the letter says. Totally understandable that they would have used a quick email, let's get this figured out. But the problem is, the public has a right to see dialogue and discussion between members of a public body. Now, if it's 2 of you, that's fine. If it's more than 2 of you, that's a quorum, just by definition. And if it is a quorum, that could very well violate the Open Meetings Act. So kind of avoid that. On informational matters, it's not a problem. If it's simply sharing where are we going to be, where are we meeting, what time, what's on the agenda, or if there's something factual to be shared for everybody, that's certainly fine. But in terms of dialogue and back and forth, and sometimes there can be a line that's crossed where to say, well, yeah, I think that's fine, or I don't like the way that's worded. Okay, at that point, for instance, let's say you're approving a resolution. Everybody says, yeah, it looks good. Not a problem. On the other hand, and this might have been something that perhaps there needed to be a correction to, or one typographical error to be corrected in a resolution that you've already looked at, looks like it's fine, but then if that email exchange turns into a dialogue, that's where you need to say, you know what, let's finalize this at the next meeting, and do that in an open session rather than trying to do it behind the by using email, because this is turning into an open meeting with the dialogue. I don't anticipate that would happen, but I was using that as an example. So that would be that. I think that answers the quorum question as well, and thank you for raising that, because we didn't that hadn't been included before when we were talking about open meetings. So in terms of public hearings, that's where public comment is permitted. When it says always inquire about public comment, it's basically to say for the record, is there any public comment? And there have been times when there have been about as many people in the audience as there is tonight, but we still recommend go ahead and ask, because that way the record's clear. If later there's an appeal, they didn't even ask for public comment. Like, actually, it was an empty room, and then we asked anyway, just in case. As noted, that's why it's important for the record. We do swear in witnesses that are presenting factual evidence, which basically means they're testifying. That is the applicant. You all, I think the board has always been very stringent about doing that. Some of our boards have been a little less stringent in that, but that's because of the nature of the beast. you're also quasi judicial. You're not going to want to hear from somebody if they're not sworn in. Now, attorneys or counsel are typically not sworn in. Under court rules, they're actually not supposed to be presenting factual information. Sometimes they do, but their role is there to argue or argue based on what other factual witnesses have presented. So they would not be doing that. Next slide, please. For public hearings, the rules of procedure certainly apply. And in terms of pre-hearing statements and reports from parties, that's part of the record that you would have with any application. And just to be clear, the board chair can regulate hearing processes to control timing. The rules are very clear about that. Typically, if there are a number of, do you typically use the 3-minute rule?
Only when we need to.
Yeah, we don't
That's
typically
exactly
have,
what
right.
I would have recommended. So you're doing what I would say. If you've got a couple of folks, if you really don't need to do it, there's no need to. Then there's no point. But if you've got 10 or 12 lined up, it's not trying to cut anybody off, but it is trying to give everybody a chance to talk, and not a hearing that goes on forever. Doesn't serve anybody either. So again, that's the power that you have. And one element sometimes of power is to say, now look, we don't need to hear the same thing. Let's say you've got 55 people. I've seen it happen in different contexts, but to say, if you all are in agreement with what somebody's saying, you all can stand up when that person's speaking. We don't need to hear the same thing 55 times. I've even heard it explained that, in fact, if I do hear it 55 times, it's not going to help your point. It's going to undercut your point entirely. But in any event, that's the power that the chair has to control the meeting. So.
Frank, you can correct me if I'm wrong, would this also fall into, the chair has the ability to set time limits for instance, on an administrative review, how long each side has to present. So that's something that occurs more often than a bunch of people coming for public testimony. It's more just two sides and how long they each have.
And in a situation like that, because in an administrative review, you're usually going to have at least two parties. Sometimes you may have more than that. Well, if you do, then it can be important so that they know. This is going to be the timeline. Each can speak here. Sometimes there may even be cross-exam, although this is on the record, so you wouldn't have any cross-examination.
No, we have had it in the past with an administrative review case. We did have cross-examination.
For appeals of staff decisions, they're not on the record, and there's no record. If someone is appealing a staff decision, it's just the planning commission, appeals of a planning commission or a historic district commission that's on the record.
Well, they're all supposed to be on the record, but if there was a need to ask additional questions, I mean, again, you're trying to decide if there was an error in what happened before, and at some level there has to be. But if we won't get into what the details were, but where needed, that can also be engaged. So I think we're ready for the next slide. So the decision, the record does automatically close with each decision, but you have traditionally closed the record before the final vote. Any discussion you have in making the decision and the decision, even if it's after the record's closed, is also going to be part of the record. But that does make clear to everybody where the collection of evidence is now ending, and in order to collect any additional evidence, you'd have to reopen the record. That can happen, but closing the record does add a measure of finality. And that's also part of the record as well. And then, of course, you do need very clear motions, and I think with trying to work on Zoom there for a couple of years, that added, we all got very used to, okay, everybody's going to be very clear in what they're doing, and very deliberate. Should always have a staff recommendation that can be modified, additional conditions and changed as needed, and any questions or clarification can also be there, and that comes to the end. I've always had a slide saying any questions, but I know, I think Judy Schwartz did not like that slide, so planning often
may
does
be
not
why it's
include
not
any
on here.
questions.
Oh, that's good.
So, and if you remember her, well, that's been a couple of years actually, that she's been retired too. So, well, I would say, I've enjoyed presenting this and going through. I think it might have been 6 or 7 years ago, but nonetheless, I do recall in going through, presenting it pretty much in the same way. But any questions before we end?
I do have one, and it's not really ex parte, but site visits. Is
Mhm.
there any issue with that? We see what's coming up. Oh, I'm gonna go check out that property, not walk around, or drive by, or anything like that.
There actually are, the HDC and I believe planning, there are some specific rules laying out site visits. I don't believe your procedural rules that just clarify, it can happen, but sometimes there are elements of procedural rules that in fact give you that level of assurance. We would generally recommend that not a quorum at the same time, but if you did need to do a site visit, and simply note that when the case is then called, to say, just to, again, best protection. If anybody has a question, just to say I did do a site visit, and that is generally the process that I've seen from other boards as well. If it's one-on-one or even two-on-one, that's not a quorum, that's not going to pose a problem. If there have been instances, I don't know about the Board of Appeals, but there have been other commissions where there has been a need, as a commission, to do a site visit. That can happen. That's not a closed meeting. Site visit's not an exception, but that can be arranged, that can be noticed, that can be at that address, and then if the public is interested in attending, members of the public, just as a city retreat, if the city does an annual retreat typically, where considering this overall strategic plan and how are we going to operate for the next year, typically there aren't formal decisions on applications or anything like that happening at such a meeting. It's primarily discussion, but you can't close it, so the public is invited to attend, and sometimes they do. This would be very similar. But on a one-on-one basis or two-on-one basis, I would simply say, just announce it when the issue's on the agenda. That shouldn't raise a problem at all. That's a good question, though, because that does come up. Occasionally, it's going to come up here.
I know of 2 or 3 that had the chicken coop, the daycare where there's a lot of traffic, and the church on Sunday morning drive-by.
The importance also of your noting that is, if your visit has any influence at all, which you would think it would, what was the point? Why would you go if it's not going to influence your
Better than
decision?
pictures on a computer to actually.
Right, but that then makes that part of the record, that in fact, part of my decision may be based on a site visit, and then in the discussion, more than likely it would come up, well, I didn't see this concern, or I did see this concern, and then we go from there.
So if there's something during a site visit that influences our decision, we should call it out specifically, verbally?
You don't have to, I wouldn't say doing it as in saying you were there and visited the site in the initial part.
I mean, more during, when we're
But
discussing the
once we're
decision.
in the discussion, not only, once you're in the discussion, I would say not only from the site visit, but any element of the record, if it's important to your decision, that should be put out there. And yes, if there was something from the site, because especially if a site visit, as we've described, it would be you on your own or with somebody else. The other members wouldn't necessarily be aware of that either, so you would want to raise that. But that would be during the discussion, during the conversation.
Okay. Phil, any other questions? No?
I want to thank you all for
I wanted to thank you
being
first.
here as well. Oh, sure.
Thank you, Frank, for a
Sure.
wonderful presentation on behalf of the board. And we found this to be very interesting and very beneficial to our work that we do here as a quasi-judicial board.
It's that word.
Yeah, got that word in there. So thank you.
I'm just gonna add one more element to this. I'm gonna pass these around. These are sample motions that I usually have at any time we have a case. I know over the years.
I'll tell you they're important.
You
because
as a
it's
board
guidance.
have kind of become in the habit of reading the resolution from the resolution. But I think we're trying to get the language for all of the Planning Commission, the Board of Appeals, Historic District Commission to kind of match. And this is language that the Planning Commission uses and that we have used, and hopefully we can get back to using that. And I'll always have that little cheat sheet out there for either an approval or denial. I guess sometimes there could be a deferral, but it'll basically have that language out there. So I just wanted to throw that out there.
So you're saying, Caroline, that
Do
instead of
that.
us reading from the packet, to read from the standard template here.
Right, and-
To make uniformity with all the
Correct.
other Gaithersburg
And
commissions
that
and
language
boards.
will also if there's a staff recommendation
Yeah.
separate from the resolution, you know, in the old days, we never had staff reports, but we've been doing that for several years now, and there's usually a recommendation in the staff report, and that should
Yeah.
have that language as well. So either using the language in the staff report or this sheet that will be on the dais with each of you.
So,
And the idea of that is it's not necessarily just to make sure everything's uniform, but that's making it easier for you in coming to the decision. You don't have to read through the entire recommendation, the entire part of the overall motion. It can be based on that. The other element is it prevents inadvertent errors in trying to read through the entire thing as well. And I'm sorry.
well, no, I just want to, because, this specifies based on the findings and conclusions outlined in the draft resolution with the X conditions provided and such. If during our discussion, for whatever reason, we do decide to approve it, but perhaps for a different reason than outlined in the.
Put it in there.
Then should we note that specifically here, or how should we specifically do that?
Yeah, I mean, you would have discussion about changes, guidance to change the resolution. Depending on how much change there was involved, it would either be something that you would reference in the motion and I would fix it up later. Or there are times where there are things that I don't know at all how a decision is going to be made, and there will be no resolution. And that would be, I guess, a slightly different motion, because you would be direct staff to adopt a resolution or to draft a resolution based on the discussion. And then I would use the discussion as the basis for a resolution, which would come back at a later meeting.
Right, right. That's just to make sure we get it right, but I think for the bulk of the issues that you're talking about, that's a template, you would add that in. And if there is an additional reason that it's not there, you'd add that in. If there's an additional condition, yes, the two staff conditions and the additional third condition, whatever that may be, you would add that in.
Okay. Is there any additional items from the staff this evening?
Now, the next meeting is October 12th. We do anticipate, strangely enough, an administrative review at that meeting. It's been a long time. So ahead of that, we'll send out an email with kind of an outline of how that typically goes, so people have an idea of process, because it's different. But those tend to be slightly longer meetings. I think we made a decision as a board a long time ago, we're not going till 1 a.m. anymore.
Not while I'm chair.
So we won't. And
You
I
will
don't
not.
think,
I don't do 1 in the morning anymore.
I don't either.
Well, I know the Animal Control Board, where there's always at least 2 parties involved and sometimes 3, because the city may have a totally independent decision. That's where the chair controlling the timeline to say each party will have 20 minutes, you all have 5 for rebuttal at the end, and they will stick to that, and you will think that in some of the Animal Control Board cases, you would think, we could go on 18 months and just continue talking the entire 18 months, even through Christmas.
We did.
But if it is limited and restricted in that way, people will find a way to get the data out and the information out to you that they have to do.
Should the parties be told in advance of the meeting the expectation for how long each of their presentations should be, or is that something that the chair will set out at the meeting?
If there's a sense that in laying out the process that you will each have a certain time frame to speak, which the chair will set, but you can estimate 20 to 30 minutes or something like that.
Yeah.
Okay.
I'm assuming it's just the 2 parties?
I don't know.
Okay. Because that can matter, and an administrative
Too
appeal.
soon to tell.
Yeah, it's also, I generally like to look at the code before I speak to anything, but I don't believe an administrative appeal is limited to only the 2, that there may be public comment as well.
Yeah.
So it may be that you have 2 parties, but 10 people with an opinion that want to share into it as well. So that could also happen, and that might be the importance of, that's harder to control because it depends on how many, but that may be the importance of everybody has 3 minutes who wants to offer a comment.
Unrelated to that news, I will not be.
No.
That's correct.
Okay.
Disappointed about not knowing that, but
Okay.
you can enjoy your administrative review.
Thank you. Thanks for the heads up. It's okay.
That's all I have.
Anything else? Sure.
I do have one item I want to
Yeah,
bring to
please,
everyone's
Greg.
attention. So, and it could affect the board. Planning staff is, in the near future, going to go through an endeavor of reviewing comprehensively our entire zoning ordinance.
Ooh, that sounds
We are
like
in
it's
the
gonna be.
process of potentially bringing on a consultant to assist with that. It's actually on the agenda Monday night to get the council to authorize city manager to negotiate and execute a contract. There may be certain things in there that will affect the board. We plan to have a lot of public participation. Again, all of you being city residents, I'm sure you will see postcards and other things about this. Again, we encourage you to be involved with the process as well. We'll bring you guys along where there's things that you need to be aware of that affect the Board of Appeals. But again, I just wanted everyone to be aware, and so you didn't just see a postcard pop up that says, hey, we're redoing chapter 24 of the zoning ordinance.
Thanks, thank you, Greg.
I do have a question associated with that. In the past, I have attended planning commission meetings, testified at them and such. I haven't done any recently, but would doing something like that potentially lead to, if a matter came before us later, would that lead to something that might be viewed as a conflict?
In what regards? In
If
being
I-
part of the discussion of the rewrite of the zoning ordinance?
Well, not that necessarily specifically, but if there was a matter before the planning commission, and as a member of the community,
You
I were to
testify.
testify,
Frank, I will let you
It
answer
could.
that.
That, it could, because if you've made a public statement, cut to the quick, let's say it's an applicant and they happen to be at the planning commission for whatever part of the development, and there could be an element of that would come to this board for a special exception, that planning may give you a recommendation, but they're not going to be able to, or it may be a variance, or it could be a combination of both, depending on what's going on. Well, let's say for that overall development plan, you were at planning and city council opposing it in some way, that could create a problem here, because the question is, can you be impartial and unbiased? And that would probably call for recusal. Not necessarily that you couldn't, because there's times when you said, well, I had an opinion on that, but I can still make a fair judgment on these issues. You probably can, but sometimes it's better for the board's decision, better for you simply to say, I'm not going to take a chance. I'm not going to allow that to be something that could be used against the board and or the city in the ultimate decision, and so I would recuse. It may come down to what's said. Simply asking a question may not be a concern. It could be that your opposition was very detailed. That then would be the time to simply announce, well, I will announce that I had spoken not in favor of this application when it was before planning, but it was on a detailed issue, and I don't think anything I said would indicate bias, and that I would be able to apply full impartiality in making a decision. That then's part of the record. If somebody has an objection, that would be the time to object. I think that would be unusual. I think recusal would probably be the safest. Again, we're speaking theoretically, Jim.
100%, yep.
So,
Okay. Any other questions, Frank? How about you?
I'm good. Thank you very much.
Karen? No? Robert?
Good to go.
Okay, all right, so, Phil, yeah. I was like, I know, one more, it's not Pete, it's Phil. All right, so anything else from the staff?
No.
All right, so I think I'm just gonna go ahead and call for an adjournment of this meeting and just state, this meeting is now adjourned.